Hey everybody, we're going to take a look at the Chapter 1 PowerPoint for Special Ed 302, the Inclusive Classroom by Mastro Pierre. So hopefully at this point you've watched the introduction video, and the point of the introduction video was to set the paradigm in which I want you to view this concept of disability. So the speaker was talking about two models of disability that I want you to reflect on. We have the medical model and the social model of disability. There are some professionals in education, schooling, special educators, speech therapists, physical therapists, that do need to and benefit from viewing a student's disability with this medical model of disability. We have extensive specialized training. We understand, we're in the top, 0.1, very, very top percentile of knowledge, understanding, awareness, sensitivity regarding issues regarding disability and students with special needs. And just in general, we are going to be doing a lot of the hard rehabilitation or remediation. That could be speech therapy, that could be reading recovery, that could be, physical therapy, occupational therapy, behavioral therapy, applied behavior analysis for students with autism, any of that good stuff. What I want you to focus on is the idea of the social model of disability. And this is the problem where we get into a lot of issues with inclusion in mainstream society. Many people at large who do not have a medical responsibility to that child believe that they have to do things in order to fix a disability. Further than that, many people in society at large view disabilities as something that they personally need to fix, or something that needs to be either fixed or changed about a person. Now, for medical professionals and people who can actually do that sort of thing, that's great. But for the most part, general educators are not in the business of fixing anybody's disability. Yes, we work with students. Yes, we provide supports with students. But the idea is that's not the same as physical therapy, occupational therapy, reading recovery therapy, speech therapy, things like that. Secondly, we want to focus on the social model of disability, because that is how we're going to spread and foster this idea and attitude and disposition of acceptance, right? We want students to be who they are and to accept students, right, for who they are. We talk about this in other sectors and other protected classes of society as well, right? We want students to be, right, themselves. Disability isn't something that needs to be fixed. Disability isn't something that's inherently negative about a person, whereas a disability is relatively neutral. Right? A person didn't have a choice, right, by and large, to have a disability. It's just something that is. Furthermore, a disability is something that can't always be corrected, and many people with disabilities is something that they live with their whole life. It's not something that can change. Yes, we can compensate for it. Yes, we can minimize the effect that it has on our lives, but it is something that's present. It is something that's a part of our identity, right? Much like certain other events or things that may have adversely affected a person growing up could affect their lives and make their lives a little bit harder. It's not something that's wrong, it's just something that is. So the less we think about having to fix a disability, as opposed to how can we support students' unique learning needs, the more we think about supporting a student's unique learning needs, the sooner we're going to be on the right track of how we should think. And that same type of attitude we can also parlay that into working with students who may not have disabilities, who may just be going through a hard time at home. Maybe they're going through a divorce, maybe there is some sort of family sickness, maybe there are things that are causing, there may be transiency in housing, socioeconomically, things like that. It's not something that we can fix. It's not something that we necessarily should be trying to fix, because we can't. We are one person. What we need to do is we need to think of how can we support, right? How can we include everybody to the maximum extent that we can. So once again, the medical model, by and large, especially to the uninformed, has a negative connotation, views disability with a negative connotation. It's something that something's wrong with somebody, something needs to be fixed with somebody, whereas the social model says that this is just a part of who someone is, and there are things that we can do to help, but at the same time, we view it more as a neutral as opposed to a negative. So that being said, we can go ahead and we can get into the PowerPoint a little bit. So what is special education? In general, it's specialized, one-on-one intervention supports for academic, social, emotional, behavioral, or physical, or any sorts of other needs that students have that is preventing them from accessing or being successful in the public school environment. This goes beyond just academics, right? This can include social skills, this can include independent living skills, this can include interpersonal skills, this can include job training and vocational skills, this can include a lot of things. Special education is more than just the room where kids go to get some extra help with reading, or a room where kids go to take their test, or that one room kind of in the corner of the building where there's the 4 or 5 kids that they go there all day and we never really see them. Special education is much, much more than that. So even in the title of our book, we're called The Inclusive Classroom, right? So the key word there is inclusion. Inclusion is a way that we want to look at teaching or educating students with disabilities. Another big buzzword that you may have heard is mainstreaming, and the book talks about some of the differences between this idea of mainstreaming and the idea of inclusion. Okay, so in the past, the idea of mainstreaming was something that it was a nicety to those students who had mild enough disabilities, or whose disabilities had either been the negative effects had been mitigated to the point where they could be successful in a general education classroom. Ergo, this idea of earning your way in to the idea of mainstreaming, earning your way into the general education classroom. The idea of inclusion is that everybody's place is in the general education classroom. That is the primary place where instruction should happen. That's the primary place where social development should happen. That's the primary place where children can model appropriate behavior, interpersonal relationships, etc. It's where people learn how to be, right, and how to grow up and how to develop as people. And if students have a need that surpasses that which we can provide in the general education classroom, then we have extra services that we can provide them outside of that capacity in the general education classroom. So anyways, that's pretty much the main point that I want you to take away from this debate between mainstreaming and inclusion. Pardon the flashing, I was just checking my stream. So person-first language. This is actually something that's hotly contested in circles of people who have disabilities. So I would like to provide a varied take on what the book talks about when they're talking about person-first language, because the book takes a pretty single-sided approach to this topic. The idea of person-first language is good. It's the idea that many people who may not be familiar, may not have a good amount of awareness or sensitivity towards disabilities, cannot see past a person's disability and see into the student's ability. okay, the disability is to that particular person, the idea of the disability outweighs any potential ability or potential that a student could have. We use person-first language, and by person-first language, we mean the following. That would be a student with a disability, a student with an intellectual disability, a student who is blind, a student with autism. The only exception to that is a deaf child. The people in the deaf community have very strong identity towards their deafness, and they want, okay, and they have chosen, okay, to maintain the deafness first, okay, in the actual labeling, and they actually go against this idea of person-first language. Because it's something that's very strong to their identity, and when we talk about culture, language is one of the main parts of culture, and for people who are deaf and using sign language, it is very much a cultural effect that it has. When you're speaking your own language with other people that speak your own language, you can get into a little subgroup which you then develop an identity towards. In general, the best practice, and you should be practicing person-first language in your schools. You always want to say, and we went through the examples, a person with a disability, and you can, whatever the disability is. And the idea behind that is that we want to see the person, right? And the disability is only a part of the person, whereas the disability does not supersede that person, right? The disability is not the biggest part of that person's life. It's just a part of many things that makes up a person's identity. Now, that being said, and by the way, you should absolutely practice this, and I would not recommend not practicing this professionally. There are many people within the disability community ranging from multiple disability categories that I personally know and have talked to and discussed this particular topic at length with them. Many people in the disability community are also against this idea of person-first language, and the rationale that I have had used to me multiple times is that we people with disabilities are the only protected class where we have to go to such extreme lengths to language police how other people refer to us. And examples that I have had given to me is you do not hear people using ethnic identities in person first. You would say a African American inventor, right? A Chinese biochemist, a Indian investor, a British soccer player, or whatever. It doesn't matter. But we hear it in common society all the time that we put that modifier first. Why are people with disabilities the only people that have to justify their humanity and their personhood before any sort of specific identity modifier? In these people's opinions, they feel that person first is not good because by saying a person in a wheelchair, you're saying that it's like you almost have to justify the fact that people with disabilities, right, myself included, are people. And to them, it's personally relatively dehumanizing to them to have such strong language policing on how people would refer and why do people have to refer to us in a way that's different than 98% of the other minority groups or subgroups, how they are referred to. Why is this different for this 1% of people but not for the other 99%? And my response is, I don't know. That's a good question. So anyways, you can take that for what it's worth, but just professionally, it is appropriate as a default to utilize person-first language. If a person with a disability asks you to refer to them in a different way, it is common courtesy to oblige that person and refer to them basically however they ask. So that's basically the debate on person-first language. My professional take is you should always use it as a default, but understand that there are many people with disabilities that see this extremely negative, borderline dehumanizing. So, like I said, professionally, you should practice this, but maybe this is something that we will come to in the future and revisit just as a sub culture, and possibly make changes to that. Now in special education we have 13 official disability categories, and there you see the word IDEA. IDEA is an acronym and it stands for the Individuals with Disabilities Education Act. We're going to talk about the legal history of special education in a little bit, but basically you need to brand this acronym IDEA into your brains. Individuals with Disabilities Education Act. This will be asked on every test for the most part. You will need to use this. This is common vernacular for all teachers for the most part. So anyways, officially we have 13 disability categories and they're all listed here. We talked about the big ones in class last week. ADHD is under other health impairments. It's a very big one. Learning disabilities, intellectual disabilities, communication disabilities, and autism spectrum. Those are going to be your big prevalent categories that you are going to see in the general education classroom, especially a fully included general education classroom. Not saying that the other subgroups aren't important, I'm just saying that prevalence, the amount of people who actually live with these disabilities, those are, 95+% of all the students with disabilities are going to be under those main categories, with the rest making up the rest of the 13 categories, but they're much, much less common. We're still going to talk to them and still give them their due diligence, but understand that we have the big hitters, and then we kind of have more secondary, at least prevalence-wise, disabilities. Some other groups that we might not think of in special education. Well, culturally and linguistically diverse groups would not necessarily need to fall under IDEA, but could get some help under Section 504 of the Rehabilitation Act as an at-risk student, or a student that might need, a little bit of extra something. We're going to talk about at-risk a lot. The idea of at-risk, it's an umbrella term, and it's used several ways, including it's used under IDEA. There's a provision of IDEA for early education, which is basically birth to 3, that says that we are not going to provide, or you do not need to provide a specific one of the 13 categories in order to be found eligible for special education services. This is often the case because developmental delays oftentimes correct themselves with or without intervention, and the long-term implications of labeling may be more negative than positive in that child's overall outcome. So we have this label of at-risk for students who may need some help, but we have not gotten to the point where we need to classify them as having one of the 13 disability categories in order to get that help. Okay. Also, students who may be flagged for some of the higher tier RTI services might be considered at risk. Also, students who might get services under Section 504 of the Rehabilitation Act also may be considered at risk. It's basically considered that we need to watch, we need to provide maybe some help, some services, but there still is we have not quite reached the point of needing the official classification and official protection of one of the 13 categories under IDEA. Gifted and talented is also one of the more unknown categories of IDEA. When we talk about special education, we talk about the idea of exceptional children, where if you look at the bell curve, we have the big hump in the middle and then the two smaller lines on either side. Those are our exceptionality statistically on both sides, on the lower end and on the higher end. And oftentimes students who are gifted and talented are very prone towards having a secondary disability, which is called being twice exceptional, which we'll get into when we get into being gifted. So understand that there are more than just the 13 categories to IDEA. There's also this idea of at risk, there's this idea of gifted and talented. So some of the legal history. So the United States has have a relatively exclusionary past, given slavery and discrimination and civil rights, needing several waves to, and we still haven't really fully achieved full civil rights for everybody. I mean, we had women's suffrage, we had the civil rights movement for, African Americans and for cultural minorities in like the 60s, and now we're going through the whole LGBT. We just legalized marriage equality, and we're still going through quite a lot of fights. There's bathroom bills and what's it called, RFRA, right here in Indiana, and all that good stuff. So we're still trying to fight this idea of exclusion as opposed to inclusion in society. So we need, right? We have thoroughly proven that we need laws to protect vulnerable classes of people. And so some of the court cases that have helped uphold those protections, Brown versus Board of Education, which had basically overturned the idea of Plessy versus Ferguson, whereas Plessy versus Ferguson said separate but equal. As it came and played out in practice, separate did definitely not equal. I guess that wasn't the best design sentence, but separate was not equal. Okay, and it was very common. So basically Brown versus Board said that we have to basically provide equitable and inclusive educational opportunities by race. Okay, and we're not even two disabilities yet. This was by race. Students with intellectual disabilities, students with most disabilities, still weren't included in general education. Most were sent to either first of all, mild disabilities, many of them weren't identified. Many were just considered slow, stupid, maybe just antsy for people who are ADHD or who had ADHD. It wasn't, we didn't have that level of understanding at that point in time. Just say, oh, they're just, he's just a little slow, right? And that was a very common attitude back in 40s, 50s, 60s. We could back the clock out 50 years, we would see a dramatic increase in the amount of people who were diagnosed or classified with actually having more mild disabilities back then. We just didn't think about it. Then, for people with more moderate and severe disabilities, didn't really include them much at all, right? We had institutions, we had special schools, such as the blind school, the deaf school, things like that, and like I said, we had institutions for people with more intellectual or physical related needs. So that was still not very inclusive. And that's where we get Mills versus this Board of Education from DC. Basically, this was a class action suit of a group of students who were denied for their academic and behavioral related disabilities, and the school basically argued that it was an undue burden on them to fund the special education of these students, and it was unfair to the other students who did not require such financial resources in order to receive an education. And basically the circuit court ruled that that was discriminatory towards that particular group of students, and this was a class action suit, which meant that we had this whole class of people that were basically guaranteed education by the result of this outcome. Okay, so Mills said that students have a right to education. Now we have Larry P. versus Riles, where it said that IQ tests were discriminatory. I always use the example of the movie Forrest Gump, where Forrest was trying to enroll in school, and he was there with his mother and the principal, his headmaster's office, whatever, and the headmaster was trying to not get Forrest to go to that particular school, and basically, had the entrance test, which was, I would assume, was an IQ test, and I don't know if they were alluding to this specifically or not, but if not, they did a darn good job of making an easy comparison to it. They say, here's where the line is where we admit our students, and here's Forrest, basically on the other side of the line. So as we've come, we notice that there's many things that standard IQ does and that they do not do, right? Standardized IQ is not a global measure of anything. Rather, it's a specific indicator on one specific day, right? It's just a general, it's just a number. It's an artificial construct people can perform differently on different days. Anybody that's taken the SAT more than one time, myself included, will know that you will perform differently on different days. You know, maybe you had a headache one day, you can perform, 150, 200 points lesser than you would the second time you took it when you were feeling better. Does that mean that you got 200 points smarter? What does 200 points mean? What is a point? What does it mean to be 200 points smarter or to perform 200 points better? It doesn't really mean anything. So the idea of using that as a sole means of exclusion was basically barred by the circuit court out in California. We also have Honig versus Doe, which had to do with behavioral issues. Basically, one way that schools were coming up with a scheme to not provide educational services to students with disabilities is that would impose, I don't want to say zero tolerance because that was a movement of the 90s, but they would basically impose the strict disciplinary protocols and procedures, and if you could kick a student out based on their behavior, then you wouldn't have to deal with them anymore. Well, basically, Honig versus Doe stated that if you're going to suspend a student for more than 10 days, that was considered a change in educational placement, and you had to convene the case conference committee to meet to discuss that and perform what we in special education call a manifestation determination, which means that we are determining whether the manifestation of the behavior, or what caused the behavior, was the disability the cause of the behavior. If yes, then we have to address the disability because we have to provide services for people with disabilities. If it isn't, then we could potentially continue on with the disciplinary procedures, but we have to come up with that manifestation determination, which is a huge legal thing, and there's lots of legal protections for the parents, for the student, to make sure that they're not being unduly kind of scooted out the door by the school district that doesn't want to deal with a child that might have a need. So anyways, some relevant legislation, moving on from court cases to legislation. Even before Section 504, the initial Rehabilitation Act was actually, one of the major authorizations of a Rehabilitation Act was in 1945, and anybody who is even a history novice will tell you what happened in 1945 is World War II ended, and we had a tremendous amount of veterans coming home with different disabilities, injuries, psychological problems. We call it PTSD now, formerly known as shell shock, that needed help, right? And they needed to get help reincorporating into civilian society. So the Rehabilitation Act was there to help them. And then here in the early 70s, they basically had some major expansions to this, which basically expanded beyond into society in general. So you can see here in 1973, the big section, there are several sections of the Rehabilitation Act. The one we're going to talk about is Section 504, which said that agencies or organizations that provide federal federal funding cannot discriminate and cannot deny people services based on their disability. The only exception to this, and this is just trivia, is the military, right? The military is the only governmentally funded agency that can discriminate against someone based on their disability. That's also a provision in one of the sections. But by and large, we're talking about the schools. So all public schools, public universities, government offices, all that good stuff, they all had to, it was all anti-discrimination based on that. Then, in 1975, what we had was Public Law 94-142, which was originally titled Education for All Handicapped Children Act, which then was named IDEA, or Individuals with Disabilities Education Act. This is the big one, especially for us in education, right? We consider this our granddaddy, and still, the king of the special education legislation. This provides universal protections for students in schools up to age 20, up to the 22nd birthday of any child, to provide them a free, appropriate public education in the least restrictive environment, which we'll talk about in a minute. No exceptions. We also had some reauthorizations a little bit later in 1978, also sometimes known as the Javits Act. the Gifted and Talented Children's Act to include students who are gifted and talented in as needing some extra help or being able to receive extra services. We had some more amendments to IDEA that added in things, transition services, early childhood services, extended school year services, all sorts of stuff. Here's the Perkins Act, which added in some provisions for vocational education, which is to help students basically get jobs and to help people with disabilities get jobs, vocational training. And here you're going to see we have some improvements and some amendments where they add in a few things. The big one here in 86, or the Education for All Handicapped Children Act, that added in the provisions for special ed preschool, basically, and then later authorizations brought it down to birth to 3. It's actually its own part of IDEA as well. So the big 3 that we're going to talk about is IDEA, Section 504, and ADA, or the Americans with Disabilities Act. So that's our 3 main big pieces of legislation that you should all know when you're out of this class. So once again, Section 504, IDEA, and ADA. So we can start with Section 504, and like I said, it's an anti-discrimination legislation that provides protections for students or for people with disabilities, for people or for any organization that is provided federal funding. Okay, so that's including public institutions or public education, public universities, government offices, all things like that. Now today, we have lots of students that utilize Section 504 because there are students that may require some help, but may not be deemed as eligible for IDEA because they do not necessarily fit into one of the 13 disability categories. But if there's a demonstrated need, we can provide them some services through Section 504, and we'll talk about that in much more detail as we get on later on in the class. So here's a nice little chart that you can see kind of the relationship between IDEA, 504, and everybody. So IDEA is a very exclusive group of people that you have to meet very, very, very specific criteria that has to be proven by independent third-party people, not just the parents, not just the school, but independent third parties. And you have to fit inside the little definition boxes provided by the government, with the exception of early childhood education, which is a little bit more open, but still at the same time you need to meet certain need criteria and etc., etc. We'll talk about that more later. Section 504 is for people that might need help but may not fit inside one of IDEA's 13 nice little boxes. And then everybody else, we can get some help for everybody. And that's where RTI comes in, our response to intervention. Right? A student without a disability might just be struggling in reading, and they may end up in a Tier 3 reading program for a little bit, which is the highest level of RTI as far as the level of support that we can give before special education. And they can be in there as long as they need to be in there, as long as they're meeting progress, and we don't need to get special ed involved because we don't need to get them involved until they don't respond to Tier 3. Okay, Americans with Disabilities Act from 1990. First George Bush signed this. This is the big blanket legislation for disability rights outside of government entities, right? This is the public sphere blanket civil right legislation for people with disabilities, which has to do with, there's 2 phrases in which that we use the verbiage a lot today. One is this idea of reasonable accommodations, and then 2 is the idea of public accommodations, and we'll go into both of those very briefly. So ADA basically requires reasonable accommodation for people who have disabilities. That is in the workplace, that can be in public, that can be in public transportation, and just in society in general. So here's some of the more specific things that ADA did. First, providing employment protection for people with disabilities. Employers cannot discriminate on the basis of disability. That's nobody. No employer can discriminate based on disability unless they feel like getting sued. Okay, Furthermore, employees may not ask if an application has a disability. That's against the law, and that's also a very easy way to get sued. Reasonable accommodations must be provided in the workplace. That could be assistive technology, that could be the use of, let's say, visual indicators for the deaf. That could be the allowance of having a service animal for someone that needs it. But basically, something that's reasonable, or reasonable accommodations. That's, the use of that things are accessible to people in wheelchairs. That's why we have your little push button doors, and why doors need to be at least 36 inches in diameter, or in width rather, pardon me. We also have public transportation, right? So buses need to be made accessible, trains need to be made accessible. We need to provide public transportation and accessible transportation. That would be like the MITS Plus. If you see MITS Plus going around, Indigo has I forget what it's called, but they have their own, pretty much every major metropolitan that's over, Kokomo has it, even mid-level cities, Muncie has it, Terre Haute has it, Kokomo has it, it doesn't have to be a big city, even smaller, mid-size, small cities have these sorts of things. Now, as far as public areas, this idea of public accommodation, that's a term that's used in a lot of lawsuits against places that are not accessible to people with disabilities. And here's the rule of thumb on that. If it's a place where the public in general would go, it has to be accessible for people with disabilities. So what does that mean? That means that if a person uses a wheelchair, they have to be able to access all areas, or at least all public areas of any sort of public accommodation. That could be a mall, a store, a restaurant, a school, although schools are protected under other legislation, among other places. We have to provide, let's say, we have to provide access to any sort of service or guide animals, including restaurants, and any other places, public transportation, etc. But basically, like I said, just in general, any place that's a place of public accommodation, a place where anybody goes, has to be accessible for people with disabilities so that they can participate in the community and the things that are out there in the community in general. So anyways, that's kind of the quick on ADA. Now, on to IDEA, Individuals with Disabilities Education Act. So there's been a bunch of different reauthorizations, but just in short, it promises students, well, the main part promises 3 to 21, or to the 22nd birthday, but also Part C promises from birth to 3. So basically from birth till this child's 22nd birthday, a student is guaranteed by federal law a free, appropriate public education in the least restrictive environment. And we're going to talk a little bit more about what that means coming up. So, free, appropriate public education. We could break that down. What does that mean? Free. Free meaning that students with disabilities do not have to pay extra for the services they receive, although they require more funding and more resources to receive the same education. If it's a public education, a student with disabilities cannot be given a financial burden in order to participate in the educational process. That's not, it's against the law, basically. Appropriate. What does appropriate mean? Appropriate means that to the maximum extent appropriate, a student will be educated with their non-disabled peers. A student will only be segregated from their non-disabled peers if we can have indisputable evidence that shows the benefit of taking them out of the general education classroom outweighs the negative or downside of doing such a thing. And remember that academics is only one part of schooling. We have interpersonal relationships, social development, emotional development. We need to be able to see, observe and model behavior. It's where we learn how to act, right? How do we learn how to act out at recess? It's those unwritten rules that we don't know except by experiencing. and taking a student away from having those options is very much discriminatory, and that's been backed up by many legal challenges. And lastly, public, which is education needs to be provided in the most local place possible. The ideal location is the general education classroom in your home district, in your neighborhood school. Now, for some people, that might not be appropriate, and we do have specialized schools, and we do have specialized resources that are available for students who do need them. But in general, by public, we mean we're not sending a student to a private or a medical institution to receive help. They're going to get help in the public school system. And then education is education. So free, appropriate public education. There's 6 major principles of IDEA, and you need to know all 6 of these for your exam. We'll go through them relatively quickly. 0 reject, if you just break it down, you could probably figure out what it means. Okay, it means that there's going to be 0 students rejected from receiving free, appropriate public education in the least restrictive environment. Okay, there's been a ton of court cases that have backed that up. People that have tried to deny services, deny placements, deny education. No, can't do that, right? All students with disabilities who have been found eligible under IDEA will receive a free, appropriate public education in the least restrictive environment. No exceptions. That's what it means when we say 0 reject. Non-discriminatory testing. If we go back to the court case of, here we go, Larry P. versus Riles, this is basically an upholding of the idea of non-discriminatory evaluation, whereas we will provide a comprehensive, which means not just the IQ test, but a functional analysis, an academic analysis, social analysis, from an independent third-party source, because parents have a vested interest and schools have a vested interest. So if you have two, somewhat biased parties, because the school has a bottom line and a budget, and the parents want everything that they can get for their child. So we have an independent third-party person, usually from the local education agency, come in and provide basically third-party testing and provide a third-party opinion as to the status, well, first of all, of the eligibility, and secondly, recommendations as far as the status of a student and what should happen and all that good stuff. But the idea of non-discriminatory evaluation is like, it's not just one test, it's a barrage of testing, and it's also done, if you need, in the child's naturalistic language that might not be English, because we have a major overrepresentation of students who are English language learners or maybe not English as first language speakers, and that's not a disability, that's just a cultural difference that student has, and they should not be treated as having a disability for just having a cultural difference. That's been backed up by a lot of lawsuits too. The third one is appropriate education. We should call that FAPE, or free appropriate public education. We've already talked about that. That we provide a free, so cost won't be a factor, appropriate, which means that they will be educated with their non-disabled peers to the maximum extent appropriate, but if they need, we have more restrictive settings, but we have to be able to prove that, right? And we need to be able to prove that in front of a court. So that's a very serious thing that you have to prove, and it's not something that's to be done willy-nilly or thoughtlessly. Public education. Fourth, the idea of the least restrictive environment. The idea that to the maximum extent appropriate, we're going to educate students with their non-disabled peers. Here's something that is a common misconception that I even hear special educators talk about. The idea of a least restrictive environment. The least restrictive environment is not, I repeat, not the general education classroom. It is not any one single placement. The least restrictive environment is a case-by-case basis made for every student, and we decide based on all of the information, based on all of the needs, based on all of the testing data, and we decide what is the best place for this student to be. What environment is that child's disability going to provide them the least amount of restriction towards being successful in school? That could be the general education classroom, which is the most inclusive setting, but maybe not the least restrictive setting. It could be homebound at a hospital, at a specialized school, which is a very not inclusive setting, but if a child needs it, it may be the least restrictive setting, because if you have a child with extreme medical needs, they may be more restricted from being able to participate in a general education classroom because they cannot get the services and supports that they require on a medical basis. So that's why we have multiple special education placement areas, and we're going to talk about the different special education placements in a minute. Pardon me, I'm going to have a drink of water here. Thank you. Fifth, the idea of due process. This is extremely important. The Individualized Education Program, or the IEP, is a legally binding document that every child who has been found eligible under IDEA has. It is a legally binding contract between the school and the parents to provide services for a child. Okay? That means that it is your law-bound duty to provide every single thing that is listed on the IEP to that child under, like I said, under penalty of law. Okay? Now that being said, the feds aren't going to come in and take you to prison if you maybe don't do something or if you maybe forget something. But if you don't do what the IEP says, the parents will take you and the school to court and sue you for a lot of money. Okay? So it's extremely important. Parents have, and the student has, a lot of due process rights. If the parent even so much as thinks and has even a modicum of evidence that the student is not getting legally bound services that have been promised to them and signed fully and freely by the school and agreed between the parents and the school, they have the right to hearings. They have the right to they have lots of rights considering or pertaining to their child. Okay, and they can use them and they will use them, and it will not end well for you if you're not providing the services that are legally guaranteed to that student. I've been on both sides of this. I have advocated for students and parents who have not gotten services in other districts than what I have been in. Then I have represented them and helped them take schools to court and sue them for not doing and being negligent. I have also had to defend myself and my actions against parents who have said that I have done the same. And yes, I have defended myself and everything was okay, but understand that parents have lots of power, okay? And you need to provide these things, because the last thing that you want to do is to have to defend yourself in a courtroom. It's not good, okay? And you know, your school's going to have to hire a lawyer. Your principal's not going to be very happy with the fact they're spending a bunch of legal money. It's really not it's not worth it to try and skirt anything, okay? And then lastly, the idea of parent participation. Parent participation is the idea that parents have the ultimate authority and right to make decisions for the well-being of their child. It makes perfect sense, right? Special education should not be a shadowy group of people meeting behind closed doors making long-term decisions about a child. That being said, the parents have to agree to every provision that's put into the IEP, as well as every they have to agree to the placement, they have to agree to the accommodations, they have to agree to any related services. The parents have to agree before anything goes into effect. And if they don't, they have a right to mediation and they have, they can take things to arbitration if they need to, and they have basically parents have a ton of rights, okay, and rightfully so, they should, okay. But basically parents have to sign off and be okay with things that are happening to their child in the school. That's the basic idea of parent participation. So basically those are the 6 principles of IDEA. You should know these inside and out for the test and just for your own well-being when you're working in the schools. Other sorts of things in IDEA: transition services, starting at age 14 in Indiana, which is different than age 16, which is the national age. In Indiana, we have Article 7, which is the special ed law in Indiana, and we have decided 14. But basically, we're going to get students started getting into adult life, and that could be post-secondary education, vocational training, and independent living. Basically, those 3 things. We start talking about them and working with them. Early childhood education. IDEA has several parts. Part C actually has to do specifically with people birth to age 3. Also, assessments. Students with disabilities, to a certain extent, can be provided and should and have to be provided testing accommodations on standardized testing. Well, students have to be provided accommodations on standardized testing. That being said, there's also a threshold of students who can be put and given alternative testing. Okay, instead of the state standardized test, there's usually alternative testing, and there's usually a quota of students who can utilize that if they need to. And then lastly, the idea of RTI, which is the idea that some money can be spent to help potentially students without, to set up RTI programs which may affect and help students without disabilities, but there's also a cap to the amount, that 15% of money. And just as trivia, if you're interested, 90+% of money that comes from schools is through state and local funding. Okay, the 2 main revenue sources from the federal government is entitlement, so Title I, and special ed, and that's less than 10 cents of every dollar comes from those federal sources, and they're meant for at-risk students. So you don't just want to willy-nilly use them for everybody; they're for those specific students, and it's protected by the federal government. So yes, RTI programs and early intervening programs can help non-disabled students, but at the same time there's a cap on how much money that you can put down on money that's earmarked for students with disabilities. IDEA 2004, or sometimes referred to as the IDEA IA, or Improvement Act. It's basically a reauthorization of IDEA, and it added in some extra stuff, including the idea of research-based progress monitoring, the changing of identification of learning disabilities from a discrepancy model to a more holistic RTI-based model, and we'll talk about what is a discrepancy model when we get to learning disabilities. But basically, we're not waiting for the kid to fail, 3 years of reading till we're like, oh, maybe there's a problem, maybe we should do something. We can be much more proactive in the identification. We're not waiting to fail, among other things. So, No Child Left Behind. We'll only briefly talk about this because this is no longer a current law, but basically this brought the idea of proficiency and high-stakes testing into the realm of education, and they also tied it with funding. But the idea is that students with disabilities are actually included in the high-stakes testing. However, there is a threshold of students who can be exempt, and those usually are students who are given the alternate assessments. But the idea of No Child Left Behind was good. It was good in theory. It was research-based practice, and it was the idea of school accountability. Right? School accountability is good. How they went about doing it maybe wasn't the best, and that might be being nice about it. But anyways, that was the main idea of No Child Left Behind. So anyways, continuum of services. Like we said, we talked about this with least restrictive environment. There's lots of places where special education happens. Most naturalistic places in the general education classroom. That's why we have several categories here that are the general education classroom. The full general education classroom with no outside support. General education classroom with some consultative services, which means you may have a special educator come in and talk to the gen ed teacher when they have some questions, they don't know what to do, blah, 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 all that good stuff. You could potentially have a full general education with a special educator in the room, right, either team or co-teaching or doing some small group activities. Then we start getting into pull-out programs, resource room, or they're spending a small percentage of the day in resource getting extra help. Then we can have, when they're starting to spend more of the day to the most of the day, we could then call them self-contained or a full-time special education classroom. So we have full-time special education classrooms, full-time special education schools, and then we have residential facilities, and then homebound hospital care. So as you can see, it definitely, as the pyramid goes down, we are increasing the how we could say, we're increasing the exclusion that's happening, but we're also increasing the amount of services and things that special services that are available in special places. If you've ever been in a life skills class, right, the general education classroom does not have the type of equipment that life skills classes have. So if a student needs that equipment, needs those services, that's why we have it. That's why we have this entire continuum. So anyways, a couple things while we wrap up. One debate is this idea of full inclusion versus the use of the continuum. The idea of full inclusion is somewhat of a buzzword that we kind of see in more, I guess, more lefty progressive circles, education circles, and the premise is very good that we want students with disabilities to be around, interact with, learn with, and be a part of general education classrooms with non-disabled peers. I absolutely agree with that. It provides early disability awareness. Little kids, right, are very impressionable, and if they see the only people with disabilities that they see in their life go to that one little room in the corner, what kind of lasting impact is that going to have on their attitude towards people with disabilities if they're never around them, if they never experience them, and they see them being segregated from a very early age? That's why I think that we're going to get into an age of disability enlightenment, where even in the workplace we're going to see much more inclusion, because how many older, and by older I'd say, you know, over 45 or 50 years old, you know, older business execs, what was their experience growing up with people with disabilities? Did they really interact with people with disabilities? Maybe, you know, maybe some had a friend, and maybe some are very caring and have a lot of awareness. By and large, a large part of society that's over that age didn't have a lot of experience because people with disabilities were segregated and they were isolated from their non-disabled peers and just never got to be around them, and that had a very negative impact on those particular people and their idea on what people with disabilities are and what they can do. So in that aspect, the idea of full inclusion is very good, because, you know, it's like there's not any different, you know, they may have something that they need, but they're not any different. That's the idea of the social model of disability, which I 100% agree with. I would never argue with that, except from the point of a special educator and from someone with the medical and the educational knowledge to utilize a medical model of disability. We understand that it is not feasible necessarily for a student to be successful, to be the most successful in a fully inclusive classroom. A student with autism who has very, you know, sensitive stimulation, or has, you know, reactions towards overstimulation, who could have a very negative reaction towards overstimulation, that could potentially cause a lot of distress, and it could cause emotional distress. It could cause lack of academic performance. It could cause inability to maintain or develop typical social or behavioral patterns and all that good stuff. So the idea of the continuum is there to allow students who absolutely need extra services to be able to get them in specialized environments. We don't put them in specialized environments to isolate them or segregate them. We put them in specialized environments to provide specialized services that cannot sufficiently be provided in more inclusive settings. That's really, that's kind of the long and the short of it. So, is one particularly more right than the other? That's not really for me to decide. Do I think that the idea of full inclusion is much more idealistic than it is pragmatic? Yeah, absolutely. The continuum of services is meant to be pragmatic. It's meant to be used because we understand that we have a variety of disabilities from extremely mild to extremely severe. In extremely mild cases may not need specialized help. In extremely severe cases, it would be negligent to not provide them specialized help. Which is why we have, once again, why we have all the different services available to the student. So, while I as a special educator tend to lean towards this idea of the continuum of services, I absolutely, without a doubt, do see the merit, and I understand the position of those people who are advocates for full inclusion. Lastly, and this is the last slide, it's the idea of teacher attitudes. Teacher attitudes can go a very long way into forming the attitudes of their students towards people with disabilities. If we take a medical model of approach towards disability in the general education classroom without having the subsequent medical knowledge, we end up being a victim of using prejudgment or prejudice, if you will, misconceptions of what we think a disability is. And ultimately we may, we see the disability as something that's wrong, something that needs to be fixed. Maybe it's a child that might need to be treated with kid gloves and not treated equally with others as their peers. And kids pick up on this right away. Anybody who ever had a fight with their little brother or sister or big brother or sister as a kid, at birthday cake time, his piece is bigger than mine, right? Anyone with a big family has probably had that fight at least one time in their life. Little kids are very wise and very smart. They can see inequality while it's taking place better than most adults who have dulled themselves to being able to look at it. They will see how you act towards students with disabilities. They will see you treating them differently. They will see you treating them with kid gloves. They will see you being hesitant to include them. They will see all of those things, and how you act, how you behave, and how you interact with students with disabilities is going to oftentimes shape the mindset and the paradigm on which those students view disability, and furthermore view students with disabilities for the rest of their life. Okay, so it's very important that we take this social model, especially as general ed teachers. It's very important that we take this social model of disability. We view disability as neutral, just as we would view hair color as neutral, or skin color as neutral, or socioeconomic status as neutral. Or you're not a bad person because you have blonde hair. You're not a bad person if you come from a single parent household. You're not a bad person if you have a disability, right? None of those make any sense. It's a neutral thing. It just is. And if we view it as such, not only will students see you doing that, but students will start to emulate that, and they will start to build, right, that acceptance. They'll build the empathy skills. They'll build the understanding skills. But it's really up to you. But understand that this is not something that you can. You will have students with disabilities in your class. You have about somewhere between 15 and 20%. I've seen various numbers. Students in the United States with some form of disability. You will not be able to avoid it. You will not be able to run from it. You are legally bound to provide educational services for students with disabilities. There's no way around it. Okay, it's not to be viewed as a chore. It's just to be viewed as it's the facts, Jack. Okay. You know, as a matter of fact, I have a friend that's getting a master's degree in education from a pretty predominant teachers college in West Central Indiana, and I'm not going to name the college because if that gets back to me that I'm naming names, it would be bad. But it's a big state school, and it's in West Central Indiana, and their project that they have, well, maybe a little bit south of that, but they have a project, and I detest this project, where they the situation is you're the special educator and you have to convince a general educator to have a student with a disability in their class. That's legitimately the assignment that they're giving out in a master's level program. Now, they may not like, you know, I'm glad that I'm not in the class, because I've personally had this conversation with people and say, well, according to this document in the federal government, you don't have a choice. You can either play ball or you can get sued and then fired. Those are your two options. So you can either provide this student their legally bound services, or you cannot do it, and then the parents will sue and then you'll get fired. The conversation's over. Okay, I don't want, so it's not something that, oh, and first of all, I mean, that shouldn't be an attitude that we should have. We shouldn't try to avoid teaching students with disabilities any more or less than we shouldn't try to avoid teaching students of another, you know, that speak other languages, that may be, you know, of low socioeconomic status, that could be of another ethnic culture, you know, that could have, you know, non-traditional family lifestyle. There's no reason to not want to teach any child. And if you have, you know, some sort of, like I said, there's no reason to not want to teach any child. And it's the attitudes that we form, and it's the attitudes that we practice that will carry over and that will rub off onto our students and ultimately affect the next generation's opinions and attitudes towards people with disabilities. So anyways, we reached the end of the Chapter 1 PowerPoint. I hope that you enjoyed the week off of class. For next week, I'm going to post an announcement as to what you need to do for class this next week. But thank you very much for tuning in, and I will see you next time.